enforcement in the digital world. The relevance of this webinar in the current circumstances, I need not emphasize, as COVID-19 has not only disrupted businesses across sectors, but the digital world seems to have given rise to IP infringement activities. This is naturally creating challenges in the area of enforcing the IP rights of owners. Friends and participants, we are extremely privileged to have with us this webinar Honorable Justice Pratibha M. Singh, Judge, Delhi High Court, someone who's not just a jurist, but has the distinction of being an expert in the area of IP, an area in which she excelled during her feisty days at the bar. But before we request her for her keynote address, we will have some valuable inputs from two other eminent speakers, Mr. Narendra Sabharwal, Chair of FICCI IP Committee, and Mr. Jyoti Sagar, Managing Partner of KNS Partners. Mr. Sabharwal, your long and fruitful tenure as Deputy Director General at WIPO has given you a cutting-edge knowledge in the area of intellectual property. The Government of India naturally invited you as the convener of the think tank entrusted with the task of drafting India's first national IPR policy released in May 2015. Mr. Sabharwal, may I request you for your formal opening and welcome address.
Thank you very much, Arun. Honorable Justice Pratibha M. Singh, Judge, Delhi High Court, Mr. Jyoti Sagar, Managing Partner, K&S Partners, Mr. Chavla, Deputy Secretary General, FICCI, ladies and gentlemen, good afternoon to you all, and a warm greeting for attending this webinar on IP protection and enforcement in the digital world. We are indeed privileged to have with us Honorable Justice Pratibha M. Singh, Judge, Delhi High Court, who has very kindly consented to deliver a keynote address on this very relevant and topical subject. Justice Singh is one of the foremost authorities on intellectual property in India and Asia Pacific. She is renowned for her abiding commitment to the development of an effective and balanced IP system and IP laws in the country, reflected in her learned judgments and pronouncement. It has been my privilege to have worked with her as part of the think tank for drafting the first national IP policy. On behalf of all of us, I would also like to warmly welcome her. I would also like to welcome Mr. Jyoti Sagar, Managing Partner, K&S Partners, and all other eminent panelists, and a large number of participants who are attending this webinar, who will be sharing their perspective on the topic that is before us today. As Mr. Chavla said, the ongoing COVID-19 pandemic has not only hugely impacted the healthcare systems and medical infrastructure in India and globally, it has also resulted in a significant downturn in the economies around the world. In India, the impact on GDP has been estimated to be close to minus 24% in Q1, April-June, in financial year 2021. In the current financial year, the GDP is estimated to contract by 10.5%. These are alarming and scary predictions. Except for the agriculture sector, most other sectors of the economy have been adversely affected. Amidst this unforeseen and unfortunate situation, one area which continues to stay increasingly relevant, not only for the health sector, but for the whole economy, is innovation and creativity catalyzed by intellectual property to create wealth, jobs, and expand markets. To take due cognizance of the importance of intellectual property rights during these unprecedented times is not an option anymore, but an imperative for our countries. Ladies and gentlemen, digital technologies and internet have opened up enormous potential for creating, reproducing, distributing, and commercializing new products, services, and solutions, and opening up new markets. Creative industries, e-commerce, mobile application-based enterprises, creative startups have shown a fast-growing trend, along with the growth of service providers and intermediaries. If we take an example of the Indian media and entertainment sector, this combined with e-commerce, IT and software industries is well placed to become the harbinger of technical and product innovation and content hub. Fresh challenges are being faced by creative industries in the digital environment on account of complex legal, technological, business, licensing, and enforcement related issues for the efficient management of IPRs. The Indian IP legislative and legal structure is strong and balanced and is fully compliant with the international commitments and national priorities, including those at the Indian Copyright Act is compliant with most international conventions and treaties in the field of copyright and related rights. India has already become a party to the Internet treaties, WCT and WPPT, and I hope they will consider becoming a partner, a member of the Beijing Treaty on audio-visual performance as well. Exceptions and limitations continue to remain of great significance in the area of industrial property and copyright, both, particularly in the digital environment, to maintain the delicate balance of public interest and private rights, and facilitate access and affordability of IP products become extremely important during the pandemic and the economic downturn. However, there is need for the IP laws to be kept under a dynamic review to periodically upgrade them. Also, we need to be open to considering enacting new laws, rules, and guidelines in areas such as data protection and privacy, e-commerce, liability of intermediary, traditional knowledge, and public funded research, to name only a few. Simultaneously, India should continue to proactively engage in policy and treaty development in international fora. The government has taken a significant step by consolidating all IP-related functions, particularly copyright, under the Department of Policy for Promotion of Industry and Internal Trade. The Intellectual Property Office of India has undertaken a variety of steps to digitalize the administration and management of IP office most payment, monitoring, and communication functions are now being done online. This working of the IPO in the digital environment has been particularly helpful during the period of pandemic. Similar steps have also been taken by the court and by IPAP. Various amendments of rules and guidelines with respect to patents, for example, the computer-related inventions guidelines, trademarks and copyright, along with several incentives and concessions, have provided an impetus to digital technologies, their utilization, and working online. The growth of digital economy has come in with a set of challenges. The menace of counterfeiting and pirated goods has become compounded in the virtual marketplace. With the COVID-19 outbreak, the counterfeiting of products and infringement of IP rights has seen a significant rise. The gap between demand and supply of useful items, whether they be soaps, masks, sanitizers, PPEs, essential drugs, etc., is increasing due to the disruption of the supply chain. The perpetrators are filling this gap by introducing counterfeited goods in the market. Encouragingly, the judiciary has adopted a stringent approach to protect various brand owners by actively passing orders in legal dispute initiated against offenders. There have also been numerous incidents of cyber crimes in the country. People tend to provide access to their personal information readily to social media websites and web channels for watching movies, videos, and gaming. Financial information too is shared by the users on various payment gateways. A large number of counterfeiters and infringers utilize the e-commerce platforms to sell their access by us shows that in the film and TV piracy in India, since the lockdown, there has been an increase of 63% and 24% respectively. Despite government actions, the peril of counterfeiting and online piracy continues to remain high and needs concerted action. Indeed, the time is opportune in my view for undertaking a full evaluation of the IPR policy, identifying gaps, and planning for future reforms in the light of development of technology, law, and market requirements. Some of these areas have already been indicated by me, and some other will, I'm sure, be touched during. I would only say that from the existing IPR policy and in the context of today's topics, we need to have a baseline survey or an IP audit of the relevant sectors. We need to have a comprehensive study following international guidelines for the economic contribution of copyrights and technology-based studies, enforcing not only copyright, but also areas of counterfeiting. There is also need for a quick passing of the Indian Cinematography Act 1902, which perhaps is pending in the Parliament at this time. May I, in conclusion, say that the three forces of deglobalization, and at one time I used to call this as the forces of economic integration, but they have quickly become forces of deglobalization. Advancement of technologies, particularly disruptive technologies and digitalization, are raising new challenges for the IP laws and their management and enforcement. The need for enhanced level of international cooperation and collaboration between the United Nations and other international agencies, NGOs, industry sectors, R&D institutions, and academia cannot be overemphasized. In the field of IP, there is need for fostering cooperation and partnership, for encouraging collaborative and open research, information, knowledge, and technology sharing, and facilitating patent pooling and other innovative licensing arrangements in order to provide easy access and affordability to IP protected products and services. I'm sure that discussion today will bring to the fore the current and many emerging issues and challenges, issues associated with the protection and enforcement of intellectual property rights in the digital world. With these words, I would like to thank you for your attention. Thank you very much.
Thank you, Mr. Sabharwal. Your suggestions have always found acceptance with the policymakers. And even in the industry, it looks upon you for guidance in various IP-sensitive sectoral issues and areas. Periodical upgradation of IP laws and to take due cognizance of IP issues, as you said, is fundamental to overcome the problems of infringement and protection of IP. Ladies and gentlemen, I will now turn to Mr. Jyoti Sagar, an eminent attorney and MD of K&S Partners, India's leading IP firm. Mr. Jyoti Sagar, may we have your observations on the topic of the webinar?
Thank you so much. I'm grateful for this opportunity. I'll try to be brief because we are all very anxious to listen to our keynote address from our respective speaker. Justice Pratibha Singh was a doyen of the IP bar, and it would not surprise us at all as she achieves that status on the bench. So we eagerly look forward to her address. So apart from being managing partner of K&S, I do have two other designations since March 2020. I hold two important positions in my household, that of the Chief Procurement Officer, which in simple term means that I have to order and oversee the inventories of provisions and other household necessities, and I have kept Amazon fairly occupied. And I am also the manager for media and entertainment content sourcing, which in simple language means that I have to make sure that all subscriptions, etc., with Netflix, Prime Video, Hotstar, Disney are all kept up to date. And these two positions have actually given me a real and practical insight into the digital economy. Let's look at the context. We are now in the fourth industrial revolution. The first was driven by steam, textiles, and railroads. The second was electricity, steel, petroleum, and mass production was the outcome. The third was driven by electronics and information technology, with large-scale automation of production as a feature. And now the fourth one is driven by digital, robotics, Internet of Things, artificial intelligence, machine learning, and the outstanding feature is disruption. It is the nature, speed, and scale of change that has never been seen before. How different is digital revolution and the digital economy from what we've experienced in the pre-digital era? Let's just contemplate a few numbers. Domo publishes and updates data about the internet. Their most recent report is April 2020. 59% of the world's population has access to internet. That's 4.57 billion active users. And on every minute on the internet, the following happens. Netflix, over 4 lakh hours of videos are downloaded. YouTube, 500 hours of video. Consumers spent $1 million. WhatsApp users share 41 million messages. Facebook has 150,000 messages, and Amazon sends 6659 of packages, of which quite a few are mine. Now, India is changing. Reports suggest that by end of 2020, there will be 700 million people with access to the internet, and 150 million will be active shoppers. Interesting feature is that rural India is leading this with 45% increase in penetration in 2019 versus a rather small 11% in urban areas. And as we just heard earlier, COVID-19 has shown some very interesting trends. 20% increase overall in e-commerce, but large growth from hinterland actually. Almost 66% from tier 2 cities and 53% from tier 3 and beyond. Many areas that concern IP lawyers, beauty and wellness, for example, FMCG, health and pharma, they have shown growths from 130% to 38%. 9 out of 10 consumers have changed traditional shopping habits. And what happens next? More than 50% of consumers have ordered products online that they would normally purchase in a store. So therefore, this might be overdose of statistics, but as you know, Mr. Sabharwal referred to film and TV piracy, and that really shows what we are facing. It shows that the consumer behavior and market constructs are changing dramatically. In the 2 sessions today, we will hear from eminent speakers who will tell us about the profound impact this virtual, borderless marketplace is having on management and protection of IP rights and multiple issues that challenges that follow. I am awaiting eagerly to learn more from the specialists who will speak this afternoon. My very best wishes for a wonderful session. Thank you so much.
Thank you, Mr. Jyotisagar. Your insights on the subject come from your vast practical experience. Brilliant statistics on the extent of digitization that the world, and particularly India, is going through. Such a phenomenal change to digitization inevitably calls for greater protection of intellectual property laws in the digital world. Undoubtedly, all stakeholders would benefit from your advice and guidance. Ladies and gentlemen, let me, without much ado, invite our keynote speaker, Justice Pratibha M. Singh, Judge, Delhi High Court. Someone who needs no introduction to the legal and IP fraternity. Her immense contribution to the development of IP law, first as a successful attorney and then as a judge, is indisputable. A leading member of the IPR think tank set up by the Government of India, she has been the recipient of innumerable awards like IP Litigator of the Year 2012, IP Lawyer of the Year 2013, Best IP Senior Counsel of the Year 2014, Woman Lawyer of the Year 2015, and an award by Business Today Group declaring her as one of the 30 most powerful women in India. An author of thought-provoking and informative articles in national and international journals, Justice Singh has given IP a new dimension, leading to innovation and growth. Last but not least, I must convey the human side of Justice Singh. She instituted a scholarship at the University of Cambridge for LLM students. Recently, she was invited by the Vice Chancellor, Cambridge University, to be part of the Circle of Advisors for India. May I now invite Justice Singh to deliver a keynote address. Justice Singh.
A very good afternoon to all of you. I hope I'm audible. It's wonderful to be back on the FICCI platform once again. Thanks to Mr. Arun Chawla and Mr. Sabharwal. They always treat me like a house guest, and I'm always there at FICCI at various seminars, and today I'm there virtually. Thank you for inviting me. Of course, Mr. Sabharwal and me have enjoyed a large time when we spent. I'm really surprised that I never met him before, the think tank, and the amount of time we spent drawing up the IPR policy was quite a memorable experience, if I can say the least. And of course, Mr. Jyoti Sagar, who always insists I should call him Jyoti, and I call him Mr. Sagar all the time. He has, been a mentor, a senior in the bar, and for me, very close to the Asian Patent Attorneys Association. He was my president in 2 terms when I was the secretary, and we have really grown the IP Association and taken up, I think, India's IP fraternity to the next level in the last 15-20 years. It's wonderful to see so many friends. I can actually, I don't see everybody on my screen, but the images which keep coming up once in a way, I think they're shuffling it. I can see so many friends from the industry who are there. I mean, I don't need to mention each of them because they're all there. I don't want to miss out on anyone. It's very nice to see all of you. And I would really wish that I could have seen everybody here, including the lawyers and my colleagues at the bar. And finally, Dipankarji and his team from FICCI. It's wonderful to be here today. Mr. Sabharwal has given you a good background of what the digital world means and what, according to him, is the way forward for IP in India. And that's always expected of Mr. Sabharwal because he's like on this policy. He just thinks that India can do a lot, much has been done and much more can be done. And Mr. Jyoti Sagar in his different avatars has told us what all he's been doing during COVID. And I thought one avatar he forgot was the avatar of the grandfather, which I think he's donning in his new capacity as the grandfather of his proud granddaughter. Yes, COVID-19 has changed all of us. It's changed us as persons, it's changed us as professionals, and I can say it's changed me as a judge. So I no longer have the feeling of walking into a courtroom with 150 lawyers waiting and everyone bowing when I enter. So today I only enter a small office which has a computer and I'm a virtual judge, almost an equal. And I think in that sense, COVID-19 has made each one of us equal without too much ado, as they say. And we've been, at least in the Delhi High Court, we've been very lucky. We are able to conduct hearings the whole day, morning to evening. Each of our judges is functioning. And I must say that judges in the Delhi High Court have really scaled up their facilities and their capabilities to be able to render justice even during the COVID scenario. Before going forward, just to speak about half a minute about the pandemic and IP's importance in the pandemic. I think, we all grew up as children understanding and being told that health is wealth. According to me, the word health has it has 3 dimensions today. First, of course, is the mental health of people, of all of us. Second is the physical health. And thirdly is the social health of people. And I think that's where seminars and webinars like this are contributing to maintain the social interaction and the social health of people. And I think this should be continued because without meeting everybody, without interacting, without exchanging thoughts and views, we all become, kind of cocooned in our own homes and offices. And that's what the digital world has done to us. It has opened up the whole world from the little offices and homes that we have. And I think health as wealth has a completely different connotation during this pandemic. And while the GDP statistics and the economic progress statistics might be alarming and scaring, as mentioned by Mr. Sabharwal, the way I look at it is the pandemic is a status quo. I feel that if we all come out of the pandemic with the status quo, mentally, physically, socially, and family-wise, I think we've all achieved something really, really great. So sometimes in life, we don't look at progress, we don't look at growth, we only look at status quo. And I think this is the way we entered the pandemic, we should be able to come out of it. And if we are able to achieve that, I think we should pat ourselves in the back as human beings first, and then as professionals, and we all do our little job that we have in whatever time is available for us with the challenges that technology has posed upon us. Coming to the significance of IP during this period, I think Mr. Sabharwal has highlighted it. Whether it's in the field of vaccines, medicines, diagnostics, PPE kits, counterfeiting, etc., etc. I think we need not emphasize on the importance of counterfeiting, importance of curbing counterfeiting, and the proliferation of counterfeiting and piracy during this period. But I also think that the online digital world has posed much more challenges than what we in fact expected when the whole pandemic started. And my intention would be to highlight a few legal areas and what the judiciary and the policy makers have done and what remains to be done. So let me start by saying that IP in the digital world is not the same. I'm sure we all know that, and that's why we are attending this seminar, and the topic of the seminar is revolving around that. Digital world has created two big changes for IP. One is it has given a bigger platform for IP. So that's the positive of the digital world. Secondly, it is also with growth started and created a little bit of, if I may say, a black mark in terms of counterfeiting and piracy. So I would look at it as a 70 or 80% and 80-20 game. While IP and IP industries and creative industries have got a much bigger growth platform during the digital world, counterfeiting and piracy needs to be curbed to ensure that that growth continues during this period. And that is what we are here to debate today. So I would be dealing with three major aspects of IP enforcement and protection in the digital world. The first and foremost, which is the most important for clients and industries as also for lawyers, is the jurisdictional issues that we face in the digital world. The biggest issue whenever a new case comes or a dispute comes for any lawyer or for an industry or for a IP owner is, where do I file the case? Do I have the flexibility to file wherever it's convenient for me? And is there anything that has been done by the judiciary to make this rule of jurisdiction more flexible in the online and the digital world? To curb counterfeiting, to avail of my remedies, do I have the flexibility? Now, what happens in the digital world is quite known. And I was watching the chat box just now, and there was an interesting question which came up by one of the viewers, I think, which said, if somebody registers a wrong domain name, starts a wrong website, similar name, similar look and feel, or something like that, what are the remedies? How do I avail of those remedies? Most of the times, I don't even know who is the person who has registered the domain name. What do I do in these situations? So both for IP practitioners and for the industry, the judgments in recent times, in the last 1 or 2 years, have been extremely dynamic and extremely pragmatic and extremely flexible, to say the least. So one of the first questions is, under a traditional civil law, you are supposed to sue where the defendant resides. That's the basic principle of the Civil Procedure Code. However, the legislature has already made an exception to that in the form of Section 134 and Section 62 by allowing IP owners to sue where they carry on business. So ideally, most plaintiffs could sue wherever they had their registered office instead of going to the defendant's jurisdiction. So this is now also quite well settled because these provisions have been interpreted by the Supreme Court and by the high courts from time to time, and most IP owners and lawyers are aware of this. But what's interesting in the digital world is, what is the meaning of carrying on business? Does carrying on business have to be a brick and mortar office? Does carrying on business have to be a physical office? Does it have to be a branch office? Does it have to be a corporate office? Is my internet website a sufficient platform to say carrying on business? So the word carrying on business from the defendant's perspective and from the plaintiff's perspective has been interpreted in 2 or 3 very important judgments, which I would like to highlight today to the audience. The first and the foremost judgment is the World Wrestling Federation judgment of the Delhi High Court Division Bench, which holds that the plaintiff need not be carrying on business even in India. He need not have an office in India. If he has a website which consumers are availing of in India or in Delhi, and they are purchasing goods off the website, that would itself be enough to invoke Section 134 and Section 62. It's called the WWE Reshma Collections Judgment. So this completely changed the way all lawyers perceived jurisdiction. It's virtual jurisdiction. The Delhi High Court can have jurisdiction. The Bombay High Court can have jurisdiction if the website of the plaintiff is accessible in Bombay or in Delhi or in Madras or in Calcutta. And if the plaintiff is carrying on business and selling its products online through the website. So for the purposes of 134 and 62, carrying on business means carrying on virtual business as well. Now, this same principle has also been adopted in the case of, I think it's a hotel case. I just can't remember the name of that case. It's a hotel case where the single judge of the Delhi High Court held if a consumer is able to book the hotel sitting in Delhi through the online platform, then that hotel is carrying on business in Delhi, even if the hotel is located maybe in Manali or in Dehradun or something like that. So the virtual carrying on business can vest a court with jurisdiction, which is absolutely unknown hitherto in civil jurisprudence. So for the digital world, the courts have completely made the rule flexible, and this happened initially with the India TV judgment of Justice Sanjay Kishan Kaul, if I recall correctly, and then the Banyan Tree judgment of the Delhi High Court. And recently there was one very interesting case of Juggernaut versus Ink Mango, where the defendant was using the trademark Juggernaut for a website, and the defendant was located in New York. Now, the question which arose before the Delhi High Court was, the defendant filed a suit in New York against the original owner, that was the plaintiff, and the plaintiff wanted an anti-suit injunction saying the defendant is carrying on business in Delhi because it is availing purposefully of the Indian jurisdiction, because it is dealing with Indian authors, it is dealing with Indian tourism places, the books which are being promoted are India-centric, and therefore the court then granted an injunction saying the defendant has availed of jurisdiction in Delhi, the defendant is operating in Delhi, and therefore an anti-suit injunction was granted. So similarly was the judgment of the single judge in Delhi High Court called Millennium and Copthorne versus Arya Plaza, where because of the interactive website, for example, suppose a hotel is using Make My Trip, or an airline is using, I'm not sure, any of the well-known websites. Even if you use a service provider who is making available the service or the product in Delhi, that would also constitute availment of jurisdiction, purposeful availment test. The third and the most important issue in jurisdiction was the judgment in the Ramdev versus Google, where the court was dealing with a situation where there was a defamatory publication, and the question was whether Google could only indulge in geo-blocking. That is, Google said that the right of free speech is different in different jurisdictions. So Indian courts can only injunct only qua Indian jurisdiction, online Indian jurisdiction. That is, the book won't be made available only for Indian viewers. So this was challenged in this case. So Google argued that geo-blocking is the way to go forward. However, the court held that if the original uploading of the defamatory book took place from Delhi or from India, then the Indian courts have the jurisdiction to direct global blocking, not geo-blocking, global blocking and global injunctions. So the digital and online space has made the issues of jurisdiction extremely flexible, and courts are kind of, if I may say, remodeling the traditional aspects of jurisdiction and adapting to the digital world. This is insofar as jurisdiction is concerned. Let's now look at the second aspect which I'll be dealing with, and that was new methods of infringement in the digital world. What are courts doing? How are they molding remedies in new aspects of infringement? So one of the first cases which happened in, which started this entire debate on how to block and how to deal with the technological challenges was in the case of Star TV, where I recall what was happening was there was cricket matches which were being telecasted on the Star platforms, various Star TV platforms. And in that case, what was happening, there were a large number of rogue websites which were very well known to only hosting infringing content. So as you all know, particular content is hosted on a particular URL that is called the Uniform Resource Locator on the website. So till about 2015-16, courts would only grant injunctions blocking the Uniform Resource Locator, that is the URL. So the injunction would be URL specific. However, it was then realized that these websites were having so much infringing content that they would move the content from one URL to the other, and they did it on a very, very quick basis. So then the entire concept of blocking of rogue websites came in, and the division bench of Delhi High Court, the single judge had granted an injunction saying this website has predominantly infringing content, so this website itself should be blocked. So the entire website was blocked. And lo and behold, you will be surprised what happened. The Department of Electronics and Telecommunication went in appeal against this order, not the infringing websites. The government went in appeal, and the government said that this would be too drastic a remedy to give, because if you block, even if that website had 10% valid content, you're blocking that 10% valid content. But the division bench then said, look, there is a balance which has to be struck. If a website is absolutely rogue and it only hosts predominantly infringing content, then the court would be entitled to block the entire website itself. So this was one of the first judgments which was passed by the Delhi High Court, saying that blocking a URL would not be sufficient because of the ease with which the URL can be changed and the entire website itself can be blocked. Whereas in the Bombay High Court, this very remedy was thought of being extremely broad, extremely wide, and Bombay High Court continued to give URL-based injunctions. So the debate on this issue continues, and I'm sure sooner or later the matter would get resolved by some judgment in the Supreme Court. But the interesting message is that courts are gearing up to deal with these situations. Different opinions are coming. There are different opinions expressed even in the public platforms about whether there should be URL-based injunctions or complete blocking of injunctions. But either way, the courts are responding. That's the most important thing that we need to remember here. Now, this was not sufficient. Something further happened last year in the Delhi High Court. What happened was, suppose a website was blocked. Let's say the website was called xyz.com. It was realized that the content was moving from xyz.com to xyz1.com. So the plaintiff would obtain an injunction on xyz.com. Then there would be another website called xyz1.com. Then there would be xyz2.com. Every time the plaintiff can't file fresh suits in the High Court. It involves legal expenses, it involves court fee, it involves judicial time. So this was becoming another proliferation of websites. So then the High Court looked at the concept of dynamic injunctions, which was, for example, in UK and in Singapore, the concept of dynamic injunction had been, used in a couple of judgments. Australia didn't agree with dynamic injunctions, but the Delhi High Court followed the UK and Singapore view and held that in such cases, the plaintiff can't be forced to every time file a fresh suit and increase the burden of enforcement of IP. The plaintiff should be allowed to seek a dynamic injunction in such cases. So what the court did was, it made a very interesting, it curated a nice remedy for the plaintiffs. So what the court did was, it said, you will get an injunction in the first place if you show it's pirated content against the whole website. Suppose a mirror website is created. All you need to do is move an application before the registrar. The registrar will only see if the new website is the same as the old, and the registrar will just pass an order directing the internet service providers to block the mirror website as well. So instead of filing a fresh suit, all the plaintiff does need to do is just move a small application, go to the registrar and say, these are the mirror websites which have come out. And the court accepted that dynamic websites, dynamic injunctions are required to protect IP rights in the digital world and to enforce the rights of IP owners. So that's insofar as the new types of remedies that are being given by courts for dealing with online infringement. Now we have a completely new dimension to infringement, taking a cue from what Mr. Jyoti Sagar started by saying. We are all now wedded to Amazon, Flipkart, Snapdeal, all these online shopping platforms. But there have been cases of late in the last 2 or 3 years where several of these platforms were found selling either counterfeited products or modified products, tampered products, etc., etc. So that's when the entire challenge of how to deal with intermediaries has come up. You will all recall that the original judgment of the Supreme Court was of Shreya Singhal, which dealt with Facebook. And the Supreme Court held that intermediaries like Facebook do not have any responsibility because they do not control the content. They are only intermediaries in the strict sense of the term. And their responsibility primarily under Section 79 of the IT Act is to only take down the content whenever somebody says that this is unlawful, illegal, or violative of any law. So from Shreya Singhal, we saw a large number of judgments emanating from various courts across the country, starting with the MySpace Supercassettes case in the Delhi High Court dealing with copyright infringement, then the Christian Louboutin case dealing with counterfeited products on the website, then the Amazon case, which was also decided by the division bench. So all these cases threw up a large number of issues. On the one hand, the IP owners said that the intermediaries are hosting these products, they are selling these products, they're also earning commissions, they also package the products, they accept the payment, but still they say they are only intermediaries and the ultimate responsibility is of the seller on the platform. On the other hand, we cannot even trace the sellers on most occasions. We don't know from where the intermediary is obtaining the seller. We don't know what is the details, contact details of the seller on the intermediary platform, on the e-commerce marketplace. We do not know as to whether these products are even genuine. There are warranties and guarantees being given by these sellers on these platforms. So the debate has started as to whether the intermediary safe harbor provision under Section 79 of the IT Act needs to be extended to active intermediaries and whether it should be only extended to passive intermediaries. I'm not sure if all of you saw the Economic Times today. It says that the US is planning to change its law under the Communications Decency Act to take away the safe harbor provisions and the immunities given to intermediaries. So this debate has also started in India. The first judgment was the MySpace judgment in Supercassettes, wherein the division bench of the High Court, Justice Bhatt's judgment, it was held that if MySpace is told about Supercassette's music being illegally streamed on the website, then MySpace would have to take it down immediately. This then led to the Christian Louboutin judgment, where various elements were listed by the court to say as to what would constitute an active intermediary or a passive intermediary, whether the, I think in that case, the platform was shopclose.com or one of such platforms. I don't recall. So the court held that the intermediary, if it crosses the line from being an intermediary to becoming an active participant in the transaction, then it stops enjoying the immunity of an intermediary. So for this, one has to see the kind of agreements that are being entered into between sellers and these platforms. What are the warranties and guarantees being taken? What are the, legitimate checks and balances being put by the e-commerce platforms? Then there was another case of Luxottica, which again was a Ray-Ban issue. And even in that case, the question was whether the website was only a facilitator or an intermediary or an active company which was involved in the transaction by itself. Then came the division bench judgment of Amazon versus Amway, wherein also the court reiterated the position in Shreya Singhal that if there is a court order or a notification, then the website will have to take down the product. Apart from these judgments on all these three aspects of online violations and online intermediaries, there are some policy changes also which are in the pipeline, if I may say. So one is the draft information technology intermediary guidelines rules of 2018, which were put up for public comment, etc. And I'm not sure as to what is the status of that. And that is also increasing whether the burden of intermediaries should be increased or not. And then there is the draft national e-commerce policy, which has been issued by the DPIIT, the earlier DIPP, on what are the obligations on e-commerce platforms to deal with counterfeiting and piracy issues, and how do e-commerce platforms ensure that counterfeited products, pirated products are not sold on their platforms. So as with the global order, I think the pandemic has, if I may say, fast forwarded the regulation and the growth of jurisprudence on online digital platforms and how to deal with these platforms. And I can only say one thing, that in conclusion, that courts have been very, very conscious of the changes that the online and digital platforms bring and the challenges which are brought. Technology really gallops forward. Courts and the law and the policy can basically, it's like a hare and the tortoise race. The hare is always running, but the tortoise ultimately catches up, if I may say so. So courts have actually recalibrated. They continue to recalibrate. The fight and the tussle between more regulation and less regulation continues. And I'm sure I can't stop but quoting Justice Ginsburg, who recently passed away, who said that the US is not known more for its eagle, but for its pendulum. Whenever the pendulum swings too far on the right or the left, it always comes back. So just in the same way, I think we always strike the balance, whether it's online or digital platforms, laws, courts, policies, they always stretch one side, come back to the middle, stretch another side, come back to the middle. But the important thing is that they keep stretching on both sides. And I think I'm very thankful for the organizers for having called me here. It's wonderful to see all you friends again, and take care of yourselves and keep good health. Thank you once again. I think.
Thank you, Justice Singh. Justice Singh, we've lost your voice.
Yes, I just said I finished. So if there's anything that you
Okay,
need.
thank you so much. Thank you for your humility as usual, and of course, your wonderful address. Truly enlightening, and I must say that the participants must have immensely benefited from your guidance, intense knowledge on the issues of IP protection in this digital era. And issues of jurisdiction, blocking of rogue websites, and challenge of dealing with the intermediary. Your address covering these important issues have indeed thought-provoking, and we look forward to and seek your guidance in future. Ladies and gentlemen, digital technology is one of
So,
the
Mr.
greatest
Chavla,
achievements of human.
I don't want to interrupt you with your other sessions. So, do I have the permission to leave? Thank you very much. And I'm sure you can see all
Yes,
the lovely
I'm
questions
aware,
that are being
I'm
put.
aware that you're pressed
Speakers
of
can.
time, and
Thank
I had to force you. Thank you so much, ma'am. Thank you.
I can hear you.
Thank you. Thank you, Mr. Sabharwal and Mr. Jyotisagar, and all our esteemed speakers and participants in the webinar. Uh, Wonderful. We will continue with the next session. Dipankar, may I request you to sort of start the new session?
Yes, Mr. Chawla, thank you so much. As we conclude the opening session, we now move on to the panel discussions, the first of which is on copyright infringement and digital piracy. I would like to briefly introduce the chair of this session, Mr. Blaise Fernandes, President and CEO, IMI, Indian Music Industry, before I invite him to take the discussion forward. Mr. Fernandes is a veteran of the M&E industry with extensive experience in this field, of which 23 years have been as head of Warner Brothers South Asia. His previous work profile includes being a part of the Warner Brothers global leadership team, serving as CEO of Gateway House, a Mumbai-based foreign policy think tank, and Senior Vice President, Corporate Affairs at Edelweiss Finance. And presently, in addition to serving as President and CEO of IMI, he's also an independent board member of Gateway House. May I now invite Mr. Fernandes to kindly chair and take us through the session, while also requesting you to please keep the time limitation in view. Mr. Fernandes, please come in.
Thank you very much, Dipankar, Mr. Chawla, Mr. Sabharwal, Mr. Sagar, my fellow panelists, and ladies and gentlemen who've made it time to kind of jump in on this webinar this afternoon of very important subject that we're discussing. It was very heartening to hear Justice Singh. What gives the creative industry the confidence in India is a very vibrant judiciary. Digital technology changes by the hour, causing fractures and fissures. And if we do not have a nimble-footed judiciary, the confidence in the creative community is going to dip. Talking of, while Justice Singh has a great track record, but talking of stalwarts, everybody talks of Mr. Sabharwal's achievements in India. In my previous assignment at Warner Brothers and now in my assignment at IMI, every time the pendulum swings by virtue of a memo or some legislation that's going to be introduced, the first point of reference to any international policy person in copyright is what is Mr. Sabharwal's position on that particular issue. So it's not only in India that he has weightage, he has weightage globally. Thank you, sir, for your opening comments. The problem is when Mr. Sabharwal makes the opening comments, he covers everything that everybody else was going to speak about. So that's the disadvantage of when he goes as opening batsman and you come in as one down, that's the disadvantage. FICCI IPR committee, I will not I won't end my opening comments without mentioning Dipankar has worked during the pandemic like there's no pandemic. The energy, he's on the ball week after week. There are calls week after week. There are discussions week after week. There are submissions. Keep doing the good work. Let me kind of get to the topic this afternoon. Okay. Copyright infringement and digital piracy, how much copying is right. But before I get into that, Mr. Sabharwal briefly touched on it. There's no macroeconomic data, but there's also no microeconomic data in terms of the loss of revenue because of piracy. And I defined piracy into three areas: digital piracy, white collar piracy, and there's an area of physical piracy that also exists in the media and entertainment sector. Okay, there is no data. We have fragments. The MPA has come out with reports, the IFPI have come out with reports, MCDCU has come out with reports, but I think if we need the government to sit up and listen, we will have as an industry to come together as a body, come up with parameters and get this done independently and independently vetted by a professional. Okay, and it has to be a mixture of both consulting work and scholarly work. And that's where we will get the government of India to kind of take attention that this is the leakages and this is the loss of revenue, loss of jobs, and loss of taxes. On the subject which I'm going to discuss today, fair use, an interesting subject. In the digital era, this is a work in progress construct, and such interactions between stakeholders, activists, and the government of India will help us find solutions to the subject where there exists no straitjacket formula. But I'd like to bring attention to the House and the audience to one fact. Starting from the state, let's not go anywhere further, starting from the state government of India. What's above the air, what's on the ground, and what's below the ground all has an economic value. But when it comes to everybody else's property, especially the creative industry, everything is fair use. And I'll give you a very small example. A circular was issued by a government department where music at weddings was supposed to be considered as fair use. Let's keep that aside. That's the government's policy. Let the courts decide, let the industry decide, and let's find a way out. But the government charges a 3% GST rate on Mangal Sutras, which is the most sacred part of an Indian wedding. So music for an Indian wedding, fair use, but we will tax the Mangal Sutra, which is the most sanctimonious part of an Indian wedding. So I just kind of give you perspective of fair use, which brings me to the next subject of social media. The proliferation of video apps and social messaging to stream repeat. We have to relook at the Intermediary Liability Act. I think Justice Singh had a few comments to make, but I'm sure my panel will have deeper insights into this. Enforcements, we'll try and touch upon briefly what's working and what's not working, from dynamic injunctions to public-private partnerships working with the government. Online piracy, I've been a strong advocacy that it has to be chemotherapy, which is the legal route, which is the executive route, as well as the legislative route, and palliative care. And my common message is, a grandmother will always tell her grandson, don't take somebody else's cycle, that's not your property. But will never hesitate to say, can you please download this for me on my iPhone because I'm struggling? Fair enough, maybe there's lack of knowledge that is also IP. But when IP becomes property, the P in the P becomes property, maybe there will be an awakening. And I think we need to as an industry, as a government, as civil society, we need to kind of get into the narrative. And, one of the things that I'm going to recommend on this panel is FICCI takes it up with the Prime Minister's office, because Prime Minister has a dialogue with the nation called Man Ki Baat. And maybe in one of these sessions on Man Ki Baat, talk about it, because creative community is not only about movies, films, books, and theater. It's also about design. It's also about fabric. It's also about GIs. So we need to if we need to be an Atmanirbhar society and economy, then respect for IP has to be a cornerstone of the Atmanirbhar construct. Lastly, I can go on and on, does the copyright protection laws have enough of teeth? But to kind of deep dive into this, I have two stalwarts. Uday Singh, who has seen the advantage of having Uday Singh on any panel is he's seen both sides of the industry, both as an investor and now as an industry custodian. And he will bring that knowledge to the table. His credentials are all available in the public domain, but one of the things I can tell you about Uday Singh, and I've worked with him for over 2 decades, or 3 decades probably, is Uday Singh rolls up his sleeves, and from the district level to the center, he is active. It is not that we are only working at the Delhi level. I have seen him in action even at the district level. Sri Rajendra Kumar is a counsel and senior partners, KNS partners. He has a 34 years hardcore IPR experience. He brings to the table advisory, policy formulation, and litigation. Again, be it at the tribunal level, the district level, or the Supreme Court, he's seen it all. And with both these gentlemen as panelists, I would like them to kind of start with opening comments and also do a little deep dive on the construct of fair use. Over to you, Uday, and then followed by Sri Rajendraji. Thank you. Uday, can I call on you? Uday?
For your kind, can you hear me?
I can hear you, yes,
Can
thank
you hear me?
Yes, yes, yes.
Thank you, Blaze, for your kind words. Yes, we've worked, I think, now almost 3 decades together. Maybe that also reminds us how old we are getting. Especially in this digital world, which is so dynamic and changing all the time. It's a tough act to follow, like he said rightly, after what Justice Pratibha Singh and Narendra Sabharwal ji have already spoken. But let me kind of lay it out in some of the points that have actually been raised and how we can address them. Let's start fair use to begin with. I mean, to me, the simple answer to fair use is a 3-step test, and what we've agreed in the Berne Convention, right? And as long as it doesn't exploit with it doesn't interfere with the normal exploitation of the rights holder, I think that's something which should be upheld. In terms of the whole idea of innovation and how whether these rules interfere with innovation, I don't think so, because I think the media and entertainment sector is probably one of the most innovative. And I think the way they have innovated has resulted in benefits even during the pandemic, where there's been substantial increase in consumption of digital technologies and the digital ecosystem as well. There's some kind of feedback noise.
Yeah.
Can I request my fellow participants to put your mics on mute, because I think somebody is speaking. Can you please mute your mics? Thank you.
So what we have to be constantly looking out for is fair use. How far and how wide can this go? And I think at the current level, what we have determined is good enough. Some might argue that there's need for more, but I think that I think the law, as you said, the pendulum has maintained the balance extremely well, and I don't see any need for any widening or making more exceptions come into the law. In terms of the challenges that we face, you're absolutely right. The number of challenges are many. Along with the digital, as Narendra Sabharwal ji has mentioned, that there's been an increase in illegitimate consumption alongside the legitimate consumption as well. And the situation, as Madam said earlier, it's complicated because these sites have got mirrors, they have alphanumeric numbers, and they keep changing and morphing all the time. And to address them, I think the judiciary with the dynamic injunctions has done an extraordinary job in meeting that challenge. Mr. Sabharwal also mentioned about the Cinematograph Act. I think we have been very, very vocal in pushing for that for many years now, and I think it's overdue, because 90% of all leaks happen at the source, which happens from camcording. And I think once that law is addressed, in a meeting last week, I was told that it might come up in the winter session, and I hope that law does go through. On the enforcement side, I think there has been some great developments with the MCDCU. Before that, with TIPCO, where local states, because it's a state subject, have taken up the initiative to be able to fight piracy at a local level. Sometimes because of the digital ecosystem and the benefits, they have been able to bring about blocks in certain areas which have been wider in reach than the jurisdiction they belong to. So just as she mentioned that jurisdiction has changed under the law in the digital ecosystem, I think it's also important to look at enforcement and whether there's a need to look at it at a central, at the central level, where you can actually, or a state has the ability in digital jurisdiction to kind of enlarge the scope, so that if you're getting a blocking order or if you're getting any kind of egregious website which is dealing with predominantly infringing content, there should be arrangements to be able to block them without having to keep on moving the legislative machinery. If enforcement had that ability, it would be of great help in dealing with piracy. The third leg of this tool, the way I would look at it, is spreading the awareness. You mentioned about how that grandmother tells the child that you can just download it, but unbeknownst to them, they're also downloading along with whatever movie or whatever they're downloading, malware, which includes identity theft and all kinds of viruses and problems which you otherwise would not like to deal with. It could also be that if you did it on a mobile phone, your phone could be hijacked and taken away without your knowledge. As with everything in piracy, we are dealing with what we call a hydra-headed monster, which keeps morphing and changing. We also see that they are also changing the way they operate. You have encrypted channels like Telegram, which are not so easy to trace. And I think MCDCU has done a good job even there in terms of penetrating some of the groups to be able to figure out how they are kind of spreading peer-to-peer piracy and kind of dealing with it. So I think in opening, what I would say is that let's hold the fair use exceptions where they are. Let's push for the Cinematograph Act, which you already mentioned earlier. Let's push for some kind of an enforcement jurisdictional capability, especially in the digital world, which allows these sites to be able to be blocked even from one location. And so that an MCDCU or any other enforcement arm has that power to be able to follow the judiciary in terms of dealing with enforcement processes and blocking these egregious sites. And the third, I think, would be also spreading awareness, like you mentioned, that people, especially when we talk of studies, you mentioned about how we do measurable studies to see how it is performing. We do a lot of measurement as we do today in terms of what are the piracy levels, how much have they dropped, what has been the percentage shift in other jurisdictions, and those kind of studies are welcome. And also another study would be a user and attitude study towards piracy. What is the reason they go for it? Because I don't think the old argument, which is a tired one, which is of affordability, availability, and acceptability is anymore, and accessibility is anymore an issue, considering that almost all the channels are available on legitimate networks today. Quite a few of them are available on AVOD or advertising-led sites, which are free for the consumer. So that argument is somewhat not gelling anymore. So we need to understand what could be the reason that they are drawn to these sites. How are they getting enticed into these sites? What are they drawn? Why are they drawn towards them? Considering that data costs in India are not too high, and I think people can easily access legitimate content today.
Thank you. That is concise, and I think you've wrapped up the entire, the whole discussion in those very, very finely selected words, and you've kind of, carpaccioed it in such a way it's so fine that it's easy to sum it up in the end. I'd now like to call upon Shri Rajendraji. Rajendraji, while Uday has touched on a lot of subject from the practitioner side and from the industry side, and rather than replicating it, because Dipankar has already raised the red flag for me in terms of that we are running late because of the spillover, I would like to focus on, does the copyright protection have enough of teeth, and what should be the industry be doing along with the bar to ensure that we kind of get the teeth sharpened to move with the, as Uday described it, the hydra. Over to you, sir. Thank you.
Thank you very much. Thank you for the opportunity. A very warm greeting to all the participants. Since most of the talking points have already been covered in terms of the case law which has evolved in India, and Justice Pratibha Singh has very succinctly and lucidly traced the legal landscape in India, I would answer my chair's question in terms of how the other jurisdictions have evolved legislative mechanisms to deal with this menace. Everyone agrees that digital piracy on the internet is perhaps the biggest challenge to creative industries today. Last year, as of June 7, 2019, the EU Parliament passed what is considered to be the most controversial piece of legislation to pass through the EU Parliament. It was in the form of Article 17 of the EU Copyright Directive. And how it differs from the old rule is very, very important, because it set an unprecedented shift in liability from the old rule. Under the old rule, Article 13 of the Copyright Directive in Europe essentially looked at the hosting defense in terms of no liability when an intermediary is simply hosting content without any participation, and it was ultimately the user who was held to be the primary infringer. Now, in terms of Article 17, which did come about last year, and it will take effect from 7th of June 2021. The good or the bad news is that the UK will not be implementing it. By next year, UK will have left the EU, so therefore it will not be implementing it. That's what it has made known. Now, this article says it prohibits content sharing platforms from displaying unlicensed copyrighted content on behalf of their users. Now, this is a dramatic shift from the hosting defense. Content sharing platforms like YouTube would be taken to court for making copyright infringing content available to the public, even where such content has been uploaded by their users. They will be treated as having communicated the works. So the acts of the intermediaries in hosting content are now defined as acts of communication. And this is definitely a very, very unprecedented shift. What it does is it requires service providers to seek authorization from right holders by way of license from the copyright owners and before the works are found to be uploaded. Now, if such authorization does not exist or is not there, then the article envisages certain safeguard. It says that the service provider would be liable unless it makes best efforts to obtain permission, and where right holders have specified works, make best efforts to ensure these works are not made available, and acts diligently and effectively in removing such infringing material. This article did have a very, very rough weather in Europe. A lot of intermediaries like Google did have a number of objections. And what it essentially means is that the intermediaries concerned should install content recognition or filtering technology, which would fall within the best efforts regime if they have to take shelter in the new regime. Now, this is one important piece of legislation that our legislators in India could look at. And the second jurisdiction where the safe harbors have played a very important role is the USA, of course, and it's called the Digital Millennium Copyright Act, which provides safe harbor for 4 specific types of activity. The provision of a network for transitory communications, which would be similar to telecommunications carriers, to system caching. The third is storage of information on systems or networks at the direction of users like Facebook or content sharing platforms. And the fourth is information location tools such as Google. Now, this safe harbor is available only if an online service provider disables or removes the access to the allegedly infringing content upon receiving a notice. Now, this is essentially the notice and takedown provision. And the USA is quite okay with this kind of safe harbor because the first amendment there interferes with all kinds of interference. And so long as there is a notice of infringement, the entity concerned or the intermediary concerned is exempt from liability. At the Indian level, there have been two important developments. One development has been legislative. We have had the Information Technology Act and amendments which happened in 2009. And the other is the Copyright Act, which was last amended in 2012. The interplay between the Information Technology Act and the Copyright Act has always been very contentious. And in fact, that interplay or tension played out in the MySpace case, which I had the fortune to argue for MySpace. I was representing MySpace. I argued this. This was an important case for us because this was the first time that we were looking at issues under the Information Technology Act. The Copyright Act had not been amended. This case goes back to 2009. And we looked for guidance within the Copyright Act itself. And Section 51 of the Copyright Act does provide for some kind of vicarious liability of a platform, a physical platform. The question was whether an internet intermediary like MySpace would qualify as such a platform. And the High Court held that yes, it would. Whether it would be liable for user-generated content. Here, the language of the provision was very interesting because unless and until the platform owner, such as MySpace, had constructive or actual knowledge of the infringing nature of the work, it could not be held liable. So therefore, it was important for any plaintiff to initially notify the copyright, the intermediary that such infringement is happening. And if the intermediary does not heed or does not take down the content, then the safe harbor would obviously be taken away and it would become a primary infringer. This stand was upheld by a division bench of Delhi High Court. And in fact, the High Court held that Section 79 is neither an enforcement provision, nor does it list out any penal consequences for non-compliance. It sets up a scheme where intermediaries have to follow certain minimum standards to avoid liability. It provides for an affirmative defense and not a blanket immunity from liability. So this was within the purview of the Information Technology Act itself. Section 81, as my colleagues on this webinar would recall, Section 81 says that it's a non-obstantive clause that copyright and patents are not affected by the IT Act. But the High Court adopted a very creative and flexible approach to marrying Section 79 with Section 51. Then in 2012, amendments to the Copyright Act happened. In fact, there are two provisions, Section 52(1)(b) and Section 52(1)(c). 52(1)(c) is primarily directed towards telecommunications carrier, backbone carriers, and 52(1)(c) was initially designed to address social networking websites, but something got lost in translation. 52(1)(c) and 52(1)(b) appear to be mirror images of each other. 52(1)(c) is not really the kind of legislative solution to internet intermediaries like Facebook, MySpace, Google, etc., because these intermediaries do not have any transient or temporary storage. I mean, the content is stored on their servers for a very, very long duration. So my comment is 52(1)(c) would need to be relooked and perhaps re-examined in terms of how Europe has created these safe harbors in terms of specific functions. And the last point I want to highlight is the dynamic injunction which Justice Pratibha has talked about, my other colleagues have talked about. This is a UTV communication matter. Would not wish to repeat what has already been said. The importance of this judgment is that in respect of rogue websites, it's very, very important for a court to design remedies which are cost effective, which inspire confidence in the judiciary. And this judgment is a stellar judgment in that direction. It is consistent with how the UK courts have fashioned out these remedies, especially Justice Anderson in the UK and elsewhere in the world. So essentially, this is what I wanted to convey on my bit today. Thank you.
Thank you very much. I've just been told by Dipankar that Q&As will be handled together for both sections. And I've been requested to kind of wrap up. Thank you, Rajendra ji. So if I have to kind of sum up this session, as Narendra ji said in the first place, that data is important, but also data loss is important. The loss of revenue is important. The second, as Uday said, build capacity both at the center and at the states with the state police departments and get public-private participation as a key factor. I think Rajendra ji brought out two very important points in his discourse. We need, as an industry, with the bench and the bar, to have more and more dialogues in terms of capacity building, in terms of training, but also case studies. And I think case studies from the globe of what's worked best in which part of the world and what's not worked to be kind of examined. And a very important observation he made is the Copyright Act has to be in conjunction with the IT Act, especially the provisions that discuss in the IT Act pertaining to copyright protection. And lastly, I think the awareness creation that at the end of the day, intellectual property is also like property. Just as you would not trespass into somebody's property knowingly or unknowingly, I think people are do trespassing into IP properties. But I think more than the theft, as Uday very rightly pointed out, and this can come across also in creating awareness, when you go to a pirated website, the malware that gets into your phone or your iPad or the computer will also have impact on those 9-digit numbers that you punch in while putting your credit card details. With that, thank you very much, Uday. Thank you very much, Rajendra ji. FICCI, great job again for kind of organizing these seminars time and again. I think piracy can take a whole day. Digital piracy can take a whole day. We'll still be running out of time. But I would like to hand over the floor again to Dipankar ji to kind of take you to the next session. Thank you, Uday. Thank you, Rajendra.
Thank you, Mr. Fernandez. Thank you so much. And Mr. Singh and Mr. Kumar for your interactions and for your observations. Moving on to the next session now, where the focus will be on the challenges and possible solutions in combating online brand infringement. Before I invite Mr. Jyoti Sagar to chair this session, I'll take this opportunity to briefly introduce him, and this will be in addition to how he introduced himself as. Mr. Sagar, who has been in practice for over 40 years, founded KNS Partners in 1994, and he also founded a corporate commercial practice, J. Sagar Associates, in 1991 as a solo practitioner, which is now one of the leading national firms with over 300 professionals. Mr. Sagar has extensive experience in a range of practice areas, including intellectual property, foreign investment and joint ventures, and technology transfers. He has also worked on several policy issues and been associated with various committees of the Government of India and Chambers of Commerce. And among other important positions that he's held, Mr. Sagar is currently Associate President of the Society of Indian Law Firms, member of the Executive Committee of the Bar Association of India, and also one of the International Vice Presidents of Asian Patent Attorney Association. Mr. Sagar is also actively associated with the voluntary sector. May I now invite Mr. Sagar to kindly chair the session and take the discussions forward.
Thank you, Dipankar, for that very generous introduction. We have 3 exceptional speakers for this particular session. So what I'm going to do is that without much ado, I think we need to go to our speakers who have very precious thoughts to share. So let me quickly introduce the panel. And I start by saying that we're delighted that two of the panelists are from the industry who have seen the issues of counterfeiting and brand protection and so on, really from the trenches, I mean, from the front lines. So let me do the introductions very, very quickly. So Dhwani Rao is head legal counsel of handling IP, digital legal, and HR legal matters at Nestle. She's also head of the data privacy for South Asia region at Nestle. So she supports the entire SAR, the South Asia region market, on a variety of intellectual property and digital legal issues. She has led very successfully anti-counterfeiting programs through this region. Specifically in the digital space, she has done extensive work on privacy, on crowdsourcing, e-commerce, and cloud computing, robotics, and Internet of Things. She has been a lawyer for 16 years, including 8 years in private practice. She is associated with the BASCAP, the Business Action to Stop Counterfeiting and Piracy International, and the International Technology Law Association, and of course, INTA, and the Inter-Pacific Bar Association. She has been coveted with a prestigious Legal Era Award in 2016 for the category of Rising Star under the age of 40 years. I'm also delighted to introduce Vijay Lakshmi Malkhani, or Vijay as she's more popularly known as. She's Senior IP Brand Protection and Foods Counsel at Hindustan Unilever Limited. She has deep experience in IP management, including litigation and monetization. At HUL, she also leads the Center for Excellence for IP, which works with teams in India and South Asia, devising strategies and for the global team for a strong IP framework for the Unilever and HUL. She teaches as a guest lecturer at the Institute of Intellectual Property Studies, and also is a guide and supervisor for dissertations at the NIMS. She was recently recognized as one of the top 100 powerful women in law by WIPF, and has also awarded the IP Star of Woman of the Year at the Global IP Awards in 2019. She is a law graduate, holds LLM in IP from Franklin Pierce School of Law, and has attended a number of distinguished programs, including IP courses at Interpol, at WIPO, Copyright Tax at Harvard, and a PG diploma from NLS Bangalore, and a PG diploma in HR. So she's also a member of the Indian Global Advisory Council of INTA and co-chairs the IPR committee of FICCI. And our last panelist for the day would be Prashanth Gupta, who's a partner in the litigation group at K&S Partners. He has extensive experience of over 16 years in handling broad range of litigation in the intellectual property space, both civil and criminal. Prashanth practices before various high courts, the District Court, and the Supreme Court of India, and also IPAB. As I said, he's been in practice for 16 years and has been involved in several landmark cases, including those related to issues of intermediary liability, divide between artistic copyright and design rights, etc. He's a law graduate and holds a Master's of Law in IP from University of Manchester. So with that, I would really go straight to my panelists, because hopefully we will get some time to have a little bit of a panel discussion at the end, and we are supposed to leave some time for Q&A, which I assume will be at least 10 minutes. So that gives just about 15 minutes to this panel. And we do have one of the panelists who has to leave a little early. So maybe I will call on Dhwani to have a go at it first, and then followed by Vijay, and then with Prashanth. So folks, try and stick to about kind of 5 minutes each. I'm sorry we've run into this little bit of a delay at the end, but I hope you would accommodate that. Thank you very much. Over to you, Dhwani.
Thank you so much, sir, and thank you, FICCI, for hosting us and calling us for this forum. Before I get into the details of anything else, I must congratulate FICCI for hosting this event and calling us and getting us to get to stimulating ideas to how we can deal with online brand protection strategies and what can we do. Obviously, as an industry, I can bring in two perspectives, and that's how Nestle looks at when it comes to online brand strategies. We are clearly steering away from just brand strategies to online brand strategies for a reason which we have already heard today in the initial sessions. And why I say that is because Nestle looks at it in two different ways. One is online brand strategies and protections, which means that the typical counterfeiting, infringement, piracy related issues come under that bucket, which is something which was already happening at the ground level and is now happening on online platforms. As Pratibha ma'am said, that it is not the same, but at the same time, principally, it brings in the same kind of complexities and issues and how to deal with it and jurisdiction issues and intermediary liability, etc. The other bucket that we look at when it comes to online branding strategies is how to protect your corporate brand assets in an online platform or in an online ecosystem. So this is how I would probably divide my two points, and I will only touch the iceberg, little on the tip of the iceberg, and it will probably not be too much of detail. We are clearly moving from a scenario where the Kirana stores or the regular Kirana stores are no more dealing with product, and they have researched their marketplace and they have researched their market models. As a result of which, we are not really talking about Amazon over here or a Zomato over here or a Flipkart over here. We're talking about these really small, unorganized sort of Kirana stores and a lot of other stores which have evolved to become like so-called e-commerce players. So we've talked a lot in detail in terms of intermediary liability and etc. But it's unfortunate to say that these people don't even come under that ambit and do not even consider themselves to come under that ambit. And that's where I'm talking about post-COVID times and during COVID times. This is the real area where we have seen this surge of counterfeit. So it's not really, you just have to call them or have to look up the app. They've created their own apps, and that's where they can you can purchase the product. What technically comes to you is something which is clearly a counterfeit, and that's the surge of areas that we are seeing. We all know that during COVID times, it's not the luxury items which were typically counterfeited. It is now moving towards food essential items, and there is a surge in counterfeit when it comes to medical and pharma related products. So this is the two key bucket items where the counterfeit is at its peak. And this is where the Kirana stores and the smaller models are actually emerging and are getting into a lot of counterfeit related issues. So at least on a positive note for the intermediaries, and there is a lot that's gone into that debate and that's been a lot that's been said about it. So I'll just touch upon how they've been dealing with it, and something that has been highly appreciated, at least within the system, and has been appreciated. They have a brand registry kind of a platform. They have takedown notices. They work around on varied issues on a one-on-one basis and are very, very conscious of counterfeit and have taken a lot of measures around it. So, and internationally, I've also seen that they have taken suo motu actions, which I completely laud. Like somebody like Alibaba and Amazon have taken a lot of suo motu actions without even involving the brand. An interesting perspective about how we come around with them. And they, in my conversations with them, it has always come around, and they say that we are also sort of brands. Like, we understand that if we are selling on an Amazon platform or if we are selling on a Zomato platform, we are equally onerous because people buy thinking that we will give you some good stuff and we will manage to get delivered to good stuff. So as a result of which, we believe they are doing their job. We believe they are doing fine. We believe that they can do more, obviously, in the context that we are in. But obviously, the key concern area, especially for food items, at least for us, is these smaller pockets where the resurgence of models and marketplaces are happening. And that's where the concentration should be. How does e-commerce policy really address it? It does address it to an extent of definitions, but it is not beyond that. I mean, these smaller models do not even know that they come under any kind of ambit and there is any kind of issue with them. How does brand play a role over here is that we leave it to the intermediaries, we leave it to the authorities to make the right kind of laws. But what is really important over here is that even the brand needs to up their requirement and need to up their skills to do the brand protection. So I read a very interesting article which essentially said that in the post-COVID era, the packaging technology is going to be the key differentiator. And that's where we are looking at. We are really trying to enhance our packaging capabilities, the technology that we can put in the format of barcode scanning, anti-counterfeiting features, certain kind of technologies, some covert and overt kind of features that we can inbuilt into the track and trace technologies that we can put in our supply chains. So these are a lot of things that the brands are doing and are expected to do. But I think the concern area is these ad hoc, smaller areas, which I thought is important to highlight in this platform. The second piece that I'm talking about is looking at the corporate assets that we have on our online platform. What is it that we do over here? Again, because of COVID, there is a surge of a lot of ransomware related issues, fraudulent practices. There are there is cyber frauds happening. There are unauthorized transactions that are happening. So much so has been happening in that ecosystem as well. And that's the place where we are again very, very concerned. During these times, as much as we are expected to do, there has been a lot of initiatives that has been taken to up that skill up and to ensure that we are trying to manage our assets and our corporate assets and our brand assets in our online platforms. So these are some of the things that we are doing in our internal ecosystems. We have upped the technological and cyber hygiene. There is a must as encryption, access control, logging and auditing issues that are being taken up very, very actively. There is multi-factor authentication that we are putting in, incident responses that has been put in place. And recently we have just put together a lot of Q&A sort of legal guidance to for people at large to sort of address any issues when they receive any kind of ransomware, malware, phishing attempts, etc. So these are some of the things that we are doing internally to enable our internal business team as well as to our consumers and users who bestow that kind of trust on us. At the same time, there is one initiative that I think is very important to highlight over here is we are coming up and we have come up with something called as an ethics model. As much as what is expected for us to take initiatives against such kind of infringements, we also internally imbibe certain kind of ethics model. And we have come up with an ethics policy as to how you're supposed to conduct yourself online, what kind of transactions you should get into, what should be the e-business models that you should get into, what kind of contracts you should have, what's the ethics that you should follow when it comes to data, augmented reality, artificial intelligence, or there are different kind of subsets of ethics policies that we are into, and we have been globally guided as to how we should be taking this forward. So I think with that, I would probably sort of sum up what I really want to talk about the online branding strategies that we have in the two key bucket items. As much as anybody else, and Indian courts out of all has been resilient during these times and have upped their skills when it comes to e-courts and technological advancement, which would have otherwise not been expected. And it's such a proud moment for us when we discuss it with our global teams where other courts have not been able to match up with this. Least is expected is that at least as an organization, as intermediaries, as any other pockets that we sort of support online brand protections is something that we should be scaling up. This is what I want to end up. Thank you.
Thank you so much, Dhwani. And Vijay is going to add her own comments and her own experiences from Hindustan Lever. And as I said, we are delighted to have two of the top consumer good companies in this country on this panel today. So Vijay, over to you, please.
Yes, sir. Good evening, everyone. Thank you, Mr. Sagar, for the kind introduction and for setting the context to our discussion, and Dhwani for your valuable insights, as always. So I had a lot of stuff, but I see that we are crunched for time. So what I'll do is I'll just talk about 2, 3 things quickly about the challenges that we have seen as an FMCG company with respect to what is being sold on, the e-commerce platforms, what actual strategy has been and what has really worked for us, and the regulatory environment around these, around the brand protection on marketplaces. So, as we've seen, the e-commerce business is rapidly growing, and the pandemic has only exponentially increased its potential during the COVID time. People who were not used to online experience have also shifted to online shopping. And while this is a positive change, it has also brought with it a number of challenges. So, the one-click technological world of today has definitely facilitated the sale of counterfeit products at an alarming rate, and this has created many challenges for brand owners. So I'll quickly outline the challenges so that people know what it is that the brand owners have to face with, and how they have to the steps that they have to take to mitigate this. So some of the challenges include, the ease with which a seller can easily get himself listed on these marketplaces under a masked identity. The pre-onboarding formalities that the marketplaces, most of them, while there are some which proactively employ very good mechanisms, most of them do not employ, pre-onboarding formalities. Therefore, the seller KYC is not really verified. So it's possible for a seller to go under a masked identity, possible for a seller to create multiple identities and accounts. So therefore, if you take down one listing or one account, there could be other listing under another account. Then the online shoppers also have limited options of checking the product before actually buying it. And therefore, the ability of a judgment call to distinguish between a genuine and fake product is also restricted. Similarly, it is also restricted for the brand owners as well. And because counterfeiters are becoming increasingly sophisticated and their products are evolving as a close copy to the originals. There's also, we've seen that there is a reluctance on, of the marketplaces to acknowledge this issue and or cooperate with the brand owners. There is also ability to easily see and copy the genuine product listings and make it look genuine, because counterfeiters nowadays have sophisticated tools at their disposal, and the internet actually aids that. Then there are sponsored listings by which the counterfeiters listings could actually come up, when you search for a genuine product. And the problem is also rapidly spreading to other digital means like closed groups, like whether it's Facebook, Insta, TikTok. And there is also an increase in, it's not only the counterfeit, that we are seeing being sold online, which is creating the problem. There's also a rapid increase in lookalikes that are being sold online, as well as leading established players are foraying into this with a closely similar private labels. So these have compounded the issue for brand owners to deal with online infringement. Now, various surveys have been conducted to see, consumer experience when they are shopping online. And one of the surveys says that 1 out of 3 online shoppers have received fake products in the past 6 months. Now, that is a very, staggering number. So how do we deal with this menace? And it's a growing menace as we see it. So at HUL, we actually follow a 4-pronged strategy, which I'll list out. The first one being that we have a robust online monitoring program with a dedicated team, which includes our in-house team members as well as tying up with external agencies which have the necessary capability to crawl the web. And they monitor infringements online virtually 24/7 and through use of intelligent tools to track and trace. Now, because we are talking about tools, I will directly segue into the technological intervention. While there are several tools out there which offer covert and overt technologies to track and trace genuine or fake goods in the real world, that is, when you actually have a product in your hand, it becomes a little complicated in the online world. That's because you can only see the image which is put up, and with the technological advancements, it's made to look very genuine. A counterfeiter can copy a genuine listing and make it look really genuine. Therefore, there is a need to rely on AI tools, parameters like consumer reviews, the pricing, the deep discounts, the bundled offers that are being offered by sellers online, to be able to make a determination whether the product that is being sold online is genuine or fake. Now, what we've also increasingly seen is that counterfeiters are becoming very smart and, gone are the traditional, methods that they used to employ, where they would directly copy a well-known brand. We've increasingly seen counterfeiters listing products without the brand name, just copying the trade dress, or listing products with a brand name with a spelling error, so that, when, say, for example, if I'm going to search for Lakme will not come up because it is listed as like me, for instance. So, that is the kind of, sophistication or evolvement that we are seeing from counterfeiter side. So that's making it increasingly difficult for brand owners to detect online counterfeits. And therefore, it is imperative that, we have to employ AI-based tools which enable us to make this determination online. The second strategy that we also adopt is partnering with the e-com players in the brand protection programs, which has helped in faster takedowns of infringing listings and sharing of information and building effective controls. So Dwani touched upon this briefly, and I would definitely second her thoughts on this, that there are certain proactive marketplaces like Amazon who are really willing to collaborate with the brand owners to protect the brand. And they have fantastic AI tools, and they are really evolving in their, to come out with, better technologies and mechanisms to be able to weed out bad actors at the first instance itself. So it's more proactive than reactive. So that is very encouraging, and I'm sure that with growing menace, the e-com platforms are also feeling the heat, and there is pressure on them also to be more collaborative with the brand owners, and it's very heartening that there are some like Amazon, like I mentioned, who are really who have come forward to collaborate with brand owners, while there are others who are working with brand owners to sort of settle this issue. The next that we use is that I'm sorry, please excuse me, I have a bad throat. So the next step that we follow is, we do not restrict it only to takedowns. We trace back the online infringement to the supply chain of counterfeiters and take end-to-end action on ground. So we often convert the online takedowns to on-ground actions, finally leading to destruction of goods, which is the logical end of any infringement action. If I may say so, some time ago, and this was also reported in all leading newspapers, we actually took a marketplace to the court, and after a lot of investigations at our own end, with the help of marketplace, after a court order, we were able to crack the supply chain, and we raided about 100 sellers in one day outside city limits. So that was the extent of the counterfeit racket that was going on, and it was one of our popular brand, which was a Ayurvedic oil which can be applied on the hair. So you can imagine the the kind of adverse effect it could create on consumers who would believe it to be a genuine brand and use it. So it was a very massive counterfeit racket which we were able to bust thanks to all these diligent actions. Last, but the most important pillar of our strategy is advocacy for a robust regulation in this area, because without proper enforcement environment or legislation, the efforts won't be fruitful. So we closely work with government and other agencies like other trade bodies like FICCI and all to bring regulations with clear accountability of all stakeholders in the e-com business. Now, since we've talked about regulation around e-commerce, I'll just give you a quick overview on the current legislation. While other co-panelists and the previous speakers have touched upon it, I would just like to talk about what is currently in vogue. So while several policy documents were introduced recently, Justice Pratibha Singh spoke about the first draft of e-com policy by DPIIT, which was released in Feb 2019. Actually, it really did not progress beyond that. The second or the revised draft is still expected from DPIIT, though I may say that a version of it is leaked and a lot of stakeholders have received it, so they know what's there in that. Now, thereafter in 2019, MoCA came out with the Consumer Protection E-commerce Guidelines and E-commerce Rules, that's Ministry of Consumer Affairs, to be incorporated under the Consumer Protection Act 2019. In July 2020, the Consumer Protection Act 2019 and the e-commerce rules were notified effective 23rd of July 2020. Now we analyzed both these, the second version that was, has come into the hands of the stakeholders, the second version of the e-com policy, as well as the Consumer Protection e-com rules. And it is really good to know that the provisions around fixing obligation on e-com platform to display, I mean, there are a lot of the provisions under those cover a lot of obligations to be imposed on e-com sellers. Like, there is an obligation on them to display the seller details on the website, which was not there earlier. The seller liability has been taken into account. Consumer facing policies like a refund, consumer grievance redressal mechanism has been provided in that. There is a provision for joint and several liability of the e-com platforms in both of these documents, albeit separately. There has been some level of distinction between both. And that is possibly to avoid some overlap in the obligations for e-com entities under both legislations. Therefore, the draft e-com policy by DPIIT mostly concentrates on how an e-com entity would operate in the country, what are the permissions, what are the compliances that it has to meet, while it's not clear which is the regulatory which would finally control the operations of the e-com entity. But the e-commerce rules under the Consumer Protection Act definitely has positive sort of provisions to deal with counterfeiting online. So I will not take much more time. With that, I will conclude, and I believe this segues into what Prashanth will speak next on the intermediary position and jurisdiction issues. Thank you so much.
Thanks, thanks, Vijay. So Prashanth, over to you.
Thank you, Jyoti, and thank you, FICCI, for organizing this webinar. And thank you, Vijay, and thank you,
Yeah.
Dhwani.
Prashanth, you need to be louder. Prashanth, you need to be a little louder.
So, am I audible now? Is it better? Hello. All right.
Thank you, Jyoti, for the introduction. And thank you, FICCI, for organizing this webinar. And thank you for Vijay and Dhwani insights as to the industry believes. Now, I know we are short on time, and I'll just wrap it up in quickly. And in fact, the problem in going last is that, one, you are always short on time, and two, whatever you want to say is mostly covered. So in a way, I know it works well, because mostly whatever I wanted to cover has already been talked about, discussed. Justice Pratibha Singh had talked about the judgments and how the judiciary is gearing up, and it's always, it's catching up with the ingenious ways as the counterfeiters are developing. So the judiciary is also catching up with ways to curb it. So I will quickly talk about three things. One, the domain name remedies. Two, what are the liabilities of an intermediaries? And three, the jurisdiction part. So talking about the domain name remedies, we are aware that there are alternate dispute remedies which are very efficacious and quick. We have INDRP for .in top-level domain names. We have UDRP policies for various other top-level domain names such as .com, .org, .biz, etc. Now, usually the time frame is very quick. There are 60 days turnaround time. Everything is done electronically, whether it is UDRP or INDRP proceedings. And specifically, INDRP proceedings are not even expensive. So generally, and I mean, we have a lot of experience and we are very positive. And talking about statistics, ONDAC reports that 97% cases filed in India before NICSI have been decided in favor of the complainant. So that's the efficacious remedy we are talking about. 60 days turnaround time and 97% in favor of the complainant. From number of cases in 1999, the first case was initiated in 1999. That year we only had one. Today, as we talk in 2020, we are already upwards of 3,000 cases as far as domain name is concerned. So judiciary has also been kind of gearing up. Justice Pratibha Singh talked about the judgment. In fact, that's judgment of Unlimited Limited itself, where some kind of prospective and dynamic injunction was sought by Hindustan Lever. But of course, because of the technical limitations, the judge noted, and the fact that there's no human intervention when somebody is trying to register a domain name and everything is automated, the Bombay High Court felt it perhaps would not be possible to grant a timely injunction where even before the registration of an infringing domain name, it could be stopped. But at the same time, it allowed, as an exception case, Hindustan Lever just file an affidavit in the court, and based on the affidavit, those the registrars would be obliged to take the domain out. So that is how the judiciary is also getting up. Talking about intermediary liability, lot of it has been spoken about. We are aware of Section 79 safe harbor provision, the common safe harbor provision, as Mr. Rajendra Kumar also mentioned. We had a recent judgment of MWay from Delhi High Court, where the division bench said that value-added services by an intermediary would not make an intermediary liable for passive infringement as a secondary infringer. And so, of course, the was not a case of passing off for infringement per se, and that was also one of the reasons the court didn't want to go into the issue. But what they did talk about was, they said there's under Section 79 of the IT Act, there's no distinction between an active intermediary or a passive intermediary. We are aware in Section 79 an intermediary is not to initiate a transmission and not to select the receiver of the transmission or indulge in any kind of selection of content. But as long as these criteria is met, and then the due diligence which is indicated in under Section 79 and the intermediary guidelines are fully complied with, an intermediary will not be held liable. So this is what the division bench of Delhi High Court has held. There's no distinction between an active intermediary or an inactive or a passive intermediary where an intermediary is not doing anything additional. So just because an intermediary has a warehouse or is adding few services of packaging or delivery methods, that would not make an intermediary liable for infringement. Talking about jurisdiction, Justice Pratibha Singh has detailed. She talked about Banyan Tree case. She talked about the WWE case. These are the two primary cases where they come to mind when we talk about jurisdiction. The plaintiffs, under the IT laws, it is possible to find cases where the plaintiff is acquitted and therefore WWE judgment becomes very relevant. That a plaintiff, even though it doesn't have actual business in the sense it doesn't have actual presence in India, could file an action based on availability of its goods through its own website, provided the other conditions such as commercial transaction and delivery of goods are concluded in a particular jurisdiction. And as far as Banyan Tree is concerned, it is talked about jurisdiction as far as Section 20 of CPC is concerned. There are three important points we need to kind of would confer jurisdiction on a court. One, the court has to see whether there has been a purposeful availment by a defendant in a particular jurisdiction. Also, the court has to see whether there was an intention to conclude commercial transaction, and see whether there was a specific targeting of the forum, which is of the forum state. So if the consumers in a forum state has been targeted, then the court has to present all the three criteria have to be met. So in digital world, and we talked about Amazon and we talked about other intermediaries. So it's, I mean, perhaps we can't even imagine a world today where we have to live without an intermediary. So of course there has to be a right balance. In India, the judiciary has been always trying to maintain a balance between intermediary liabilities and also to protect brand owners. Of course, the idea is to curb counterfeiting, and I think that is the right intent. And so we're very encouraged to hear Justice Pratibha Singh, the intention of judiciary is to curb counterfeiting. So this is, and any question we'll be happy to take. Over to Jyoti.
Thank you. Dipankar, are you online?
Yes, sir, we are.
Yeah, Dipankar, I do need to break off. I have it was another call at now, and I didn't expect that this could be delayed. So can we take the questions, please? If there are any, will you be able to handle
we can
them?
maybe take
I'm really sorry,
yes.
but I need to log off. I have to get into another call.
Sure, sir.
So can you please just handle those, and then between I think Vijay and Prashanth are still there. Dhwani would have left by now. I'm sure they'll be able to answer the questions for the audience. Thank you so much.
Thank you, Mr. Sagar. Thank you for chairing this session, and really grateful for your presence today. And meanwhile, if there are any questions from the audience, we'd be happy to take one or two, despite the overrunning of the time. Any questions? Please use the raise hand option, and we will let you in. We'll bring you in. Well, we don't seem to have any questions.
Yeah, so Dipankar, this is Krishna.
Yeah, Krishna, please go on.
Yeah, so I think I have a question for Vijay. So Vijay, thank you, a great session. So just
Yes,
a question on when you see the post-COVID the counterfeiting issues in food products. So what is the system now with respect to various regulations like you have FICCI, you have the Legal Metrology Act. So when the infringement is happening, how are these two different bodies like Legal Metrology Act and the FICCI, governance body helping in fighting against counterfeit? Any help or no?
Yes, sir, they do help, but what happens is, and this has been our experience. Unfortunately, the police and these regulatory bodies don't collaborate very well. So therefore, it is difficult to get both of them on the scene, because if we are looking at a FSSI kind of a raid, it will not be a civil action. We'll have to take the raid route. So that is the only challenge. But yes, we've had instances where we have passed on the information to the FSSI authorities, and they have also helped us in these kind of raids.
Okay.
But it takes some time. Because you have to pass on the information, and they have their own process, and thereafter they take action. So therefore, if it is counterfeit in the interest of time and to prevent any leak of information, we generally follow the civil route, or where the police, we know that the police is active and does take IP action. So we go through that route.
Okay, so I think counterfeit, it's still a challenge against fly-by-night operators, and it's a pain.
Absolutely, sir.
Yeah. Thank you.
Thank you, Vijay. Is there any other questions? Please, like I said, use the raise hand question.
Dipankar, I see 2 questions in the chat box.
All right. Would you like to answer them?
Okay, I think, okay, one I can. I think Amber has asked, I'm looking for seeking dynamic injunction for fake FB pages for our brand. Any suggestions? So, frankly, our experience, at least before the Mumbai High Court, is that they are not inclined to grant dynamic injunction. I am aware, and like Justice Pratibha Singh said, the Delhi High Court does grant dynamic injunction, but but the Bombay High Court is not inclined to grant dynamic injunction. We recently filed a suit against a fake domain name. which was inviting distributorship, and that was during COVID time, and we thought it's very serious and we should be getting dynamic injunction, but Justice Patel took a totally different view for reasons rightly listed by him. So that is what I would like to tell you. So probably if you can make out a jurisdiction in Delhi, there are a lot of precedents and that may probably help you. And because it's FB, it's a FB page, I think you would be able to make out a case for jurisdiction before the Delhi High Court. Prashanth can correct me.
Yes. So, see, the dynamic injunctions that have been granted so far are in Delhi High Court are also pertaining to rogue websites, primarily on the piracy issue. As far as trademark infringement is concerned, we really don't have any direct precedent as such. And as also indicated in the Bombay High Court judgment by Justice Patel, some of the issues here, we have technical challenges. For example, in intermediary, unless there's a court order, for example, if it is a case of defamation, etc., may not be able to take down anything. Even for an intermediary to take down anything without intimation is very difficult. And that's why the Facebook MySpace judgment MySpace judgment also recognized that until there is a specific URL, an intermediary would not be able to make out whether what to take down and what not to take down. So as far as intermediaries are concerned, most intermediaries, as you would have heard other panelists as well, especially Dhwani pointed out, are happy to act upon receiving complaints from brand owners. So I think it would be difficult to get a blanket prospective dynamic injunction as far as trademark infringement is concerned. However, it is always possible to write to an intermediary such as Facebook, and our experience is that they are generally cooperative and they take it up. I hope that answers.
Yeah, it does. I think Richa was trying to raise her hand. Do you have a question, Richa?
Yeah, hello to all the panelists. So my question was that so as far as current situation is there, because if we inform the intermediary, IP owner informs the intermediary, within 36 hours the intermediary has to take down the infringing content. However, since this becomes a very repetitive exercise, because it's very difficult sometimes for the infringer also, for the IP owner also, to keep a check on the infringing content. So I wanted to know if there were any views of the panelists with regard to whether there should be any amendment made in the IT Act itself to define the role of intermediary in order to resolve this issue. Because what happens is, even if within those 36 hours also the IP owner is suffering damages, because his IP is being infringed continuously and there is no one to redress or reverse that damage. So I just wanted to know if there were any views with regard to that.
So yeah, I can take that question. Thank you, Richa. As I mentioned, it's very difficult task to actually maintain a balance, a right balance between rights of an owner, the brand owner, and also the freedom which an individual requires to operate. Because most of the things which happen online are automated processes, and unless there's a specific complaint to the intermediary, an intermediary would not be able to judge on its own as to what is infringing and what is not. And I do understand, but that if they're repetitive and same marks being infringed by other entities, then there should be something that makes the intermediary liable to take the infringing product down. So I think perhaps the challenge is technological, and once there are ways technologically to address it, I'm sure the law would also mend itself. But I guess that today the law has its own limitation because of the technological limitations along with it. Maybe other panelists could add on and add their views.
Yeah, I agree, Prashanth, and I think with the if the e-com draft policy comes in soon, and with the regulations under the Consumer Protection Act, I think they've tried to fairly cover the liability of the e-com platform. There is a provision for holding them liable also in cases where counterfeits have been found to be sold on their platforms. So I think this is an evolving space, and the intermediary definition itself covers a lot of it's quite broad. So to amend that, I think I don't think that may be the right thing, but probably through other laws, probably we could put in more reasonable restrictions on an e-com entity, because you cannot obviously do something which would be in restraint of their trade as well. So there has to be a balance, like Prashanth has rightly pointed out.
I'm sorry to, my apologies, but we're really running out of time now. And I will take one more question, and I can see one from Achal Shekhar. I hope that's okay with all the participants. I would like to know, she's asking, if I can initiate criminal action against a mirror website, even if I do not have contents of my website registered as copyright. This pertains to the earlier session 1. Anyone?
Yeah. I'll take it. I'm Rajendra Kumar this side. Yes, it is permissible to take criminal action because the Copyright Act does provide for criminal action. But the mirror website that evolved in the dynamic injunction case was essentially in the context of facilitating efficacious adjudication of issues. However, if one were to go after a separate mirror website under the Copyright Act, the very same rules would apply. Copyright doesn't have to be registered. If one is able to make out that it does infringe, that is good enough.
Right, Rajanji. Thank you so much. With this and with the permission of Mr. Sagar, I'd like to conclude this session. Is that okay, sir?
Devankaji, I believe Mr. Sagar has
already left. Yeah.
All right. Then I will take the opportunity of, well, ladies and gentlemen, as we conclude a very engrossing and informative webinar, I'd like to, on behalf of FICCI and all the participants, once again, thank Honorable Justice Pratibha Singh for our keynote address, as well as all the other dignitaries, Mr. Narendra Sabharwal, Mr. Sagar, Mr. Chawla, for their observations during the opening session, and Mr. Blaise Fernandez and Mr. Sagar once again for very ably chairing the sessions, and all the distinguished panels, Mr. Uday Singh, Mr. Rajendra Kumar, Ms. Vijay Lakshmi Malkhani, Ms. Dhwani Rao, and Mr. Prashanth Gupta for their insightful observations and for your interactions with the participants. I also would like to extend our sincere thanks to KNS partners for associating with FICCI to conduct this webinar today, and to Ms. Kavita Vij of KNS Partners for her valuable support in organizing it. And of course, our very heartfelt thanks to all the participants for joining us today in such a large number, and for your attention and interaction. We sure hope you found the discussions useful and informative. Once again, thank you all, and please take care of yourself and stay safe and healthy. Thank you.
Thanks, Dipankar. Thank you. Thank you very much.
Thank you, everyone. Thank you.